Your Honor, I just handed this honorable court and the parties, although I ran out of copies, I just gave it to Mr. Matthews. The case I cited in motion limiting number 62, Ebersole, E-B-E-R-S-O-L-E versus State. It's 371 Georgia Appeal, 520. It's in Division 1C as in Colette. It's 901 Southeast 2D, 572, 2024 case. And Your Honor, what happened in our case previously, and I understand this honorable court was not with us, but the prosecution through ATF agent Reese was testifying. He was at one time with Cobb County Police Department, and he was the lead detective on a case against Mr. Jimmy Winfrey, and that is in Cobb County case number 15-9-2765. And he was asked by Prosecutor Hilton about a jail call. And the jail call had something to the effect of, when Mr. Winfrey comes home, he will be given a Porsche and $250,000. It was something to that effect. And Ms. Hilton then asked Detective Reese, within approximately a month from that time, that jail call that the jurors just heard, did in fact Mr. Winfrey enter a guilty plea? I objected. That guilty plea was vacated and found to be coerced by the Georgia Supreme Court in Winfrey, W-I-N-F-R-E-Y versus State, 304 Georgia, 94, 816 Southeast 2D, 613, 2018. And it says specifically in that case that that guilty plea is void, is null, and cannot be used for any purpose. We approached the predecessor judge, and he said he didn't know about that case. It's all on the record. It was at the bench. And I said, well, here's the site. And he said, well, I'm not going to read it. And I said, well, I'm going to cross him on it, and I'm going to subpoena the lawyers, and I put them on my witness list who entered that plea, and I have a certified copy of the Supreme Court opinion vacating it, and the predecessor judge said I couldn't do any of that. Ms. Hilton then came back to the podium and asked Agent Reese the next series of questions. Well, was that plea, for whatever reason, vacated, and a short time later did Mr. Winfrey enter a guilty plea? I again objected. I was not allowed to go into it. The essence of this motion, number 62 of Mr. Williams, is I believe that that's already a constitutional violation. So it has to be harmless beyond a reasonable doubt. Because
was there any kind of instruction?
No. No, it was, I can't cross on it. Mr. Matthews can't cross on it. We were all barred. And it came out that way, that Mr. Winfrey pled guilty. And this dealt with the April 26, 2015 tour bus shooting of a gentleman named Dwayne Carter. He's a phenomenal artist, musical artist, known as Lil Wayne. So the state gets that in. Now, the predecessor judge did keep out the indictment on my objection, because the indictment names as co-conspirators, unindicted co-conspirators, Mr. Williams in that event, and it was a RICO count. The further objection was that Mr. Winfrey, he didn't really plead guilty. This is the most favorable Alford plea, and I attached it to Mr. Williams' number 62 that, that I have seen, where the predecessor judge specifically, excuse me, not the predecessor judge, Judge Staley, it's S-T-A-L-E-Y, and it's Staley Clark, C-L-A-R-K, Cobb County Superior Court. She specifically acknowledges that this is not a guilty plea. This is a best interest plea. He's not entering admission of guilt. The Honorable Steve Sadow, which is Steve, S-T-E-V-E, and Sadow is S-A-D-O-W, was the lawyer. He specifically said that we are doing this just because it's been 5 years and Mr. Winfrey wants to get out of custody. And I attached that, and I have a certified copy of that Alford plea. Anyway, the way it came in was so wrong, and we had cases that we were citing to the predecessor judge explaining that a person who's not testifying, the fact that they pled guilty, people plead guilty for any numerous reasons, should not be allowed to come in against Mr. Williams and the others here. So going forward, I put this on this court, honorable court's radar, because it is my belief and understanding, and if it's not going to happen, that's great, that Mr. Kendrick has pled guilty to being in a criminal street gang, specifically YSL, when he was with Mr. Martinez-Arnold. Martinez-Arnold is going to be a witness, but he did not plead guilty to that charge. And it's my understanding that the state intends to have an exhibit, a certified copy of the guilty plea of Mr. Kendrick. And that should not come in against Mr. Williams or any of the other people here for the same reason.
Let me stop and ask the state. Is your position that it comes in against anybody other than Mr. Kendrick?
I don't believe that a certified copy of Kendrick's conviction would be admissible against another defendant besides Kendrick. And additionally, we intentionally did not tender the certified for Jimmy Winfrey.
For Mr. Winfrey?
Correct. The court did not preclude us. We did not tender it.
Right. Okay, so is it the state's position that not the certified copy of the conviction, but the fact of Mr. Kendrick pleading guilty to, it was gang activity and the gang being YSL? What's the state's position on that with regard to that information coming in on anybody else?
I think that his guilty plea, the fact of his guilty plea is admissible against him, and I don't believe that it's admissible in normal cases against anyone else. In this circumstance, I also don't believe that it is. At this time, I don't believe the cases that I've read suggest that it would not be admissible against another defendant. That's
all right. I think that's generally correct. So I think I've mentioned before needing a limiting instruction, and I know we're not quite at that stage yet, but I don't know when you intend to introduce that. And
not for the next 2 weeks, I believe.
Okay. Well, can you go ahead and be trying to put together whatever appropriate limiting instruction there would be? And then I would think that the position of both the defense and the state would be the same with regard to Mr. Ryan's murder jury verdict.
Right. Well, yeah, I know that the court, I know we addressed it last week, and I was saying that I was looking into that. So I don't have anything to counter the position that it's only admissible against Ryan. I don't have anything to counter that position yet.
So we'd need a similar limiting instruction for that. Let me ask the defendants with regard to whatever information did come in on Mr. Winfrey having pled, that having been introduce that concept to this jury at this point. Does the defense want me to instruct time at the end of the case? hey, with regard to what you heard about Mr. Winfrey's plea, that was also a best interest plea, and so the same things apply?
Yes, and I intend involuntarily given and then call Mr. Sadow.
All right, well, I don't know that we're going to be doing all of that, because if it is before the jury that the other one was overruled, then the other one really doesn't need to be taken into consideration.
It was not before the jury. The other one's overruled. And please, we have to look at the transcript.
Okay.
But it was something to the effect of later, for whatever reason, a short while later, did he re-enter his guilty plea?
Okay, well, maybe we will get the necessary information to the jury without having to do it through a couple of witnesses. Maybe y'all could work on a stipulation. Why don't y'all make efforts to work on a stipulation that would cover that?
Also, Your Honor, there was the matter of the playing of Mr. Zachary's 2017 interview by Mr. Williams. Your Honor, if I am not mistaken, that the portions that were played included a reference by Mr. Zachary to the fact that Mr. Winfrey had entered that guilty plea. If I'm wrong, I accept that, but my memory is that from the time that it was first broached way back when, earlier this year in April or whenever it was, and now, a video, the witness that was being interviewed actually talked about that guilty plea.
Well, that may be, but regardless, we need the correct information in front of the jury. So,
Can I just make a statement on that? Is that okay?
yeah.
So, pled guilty, but to say that I somehow then introduced that concept, I'm dealing with a fact that already came out before the jury.
Come out, right?
So I don't think that holds much weight.
Yeah, but I would like for y'all to try to figure out a stipulation that will cover what the situation was, and then I'll give an instruction about that having ultimately been a best interest plea.
Okay.
Okay.
When I say okay, I still intend to call the witnesses, but I will follow your direction.
Okay. Well, I mean, if that's what's necessary, that's what's necessary, but I don't believe it should ultimately. I think there are a stipulation that could be worked out, and if it's not a stipulation, then you can just propose there, maybe. Okay. All right.
Thank you.
Okay. So. So on motion in limine 61, there was one part that was, which was the issue of the text messages that are captured through the wiretap, and there's, I guess, a best evidence objection to that. So what's the state's intent on that?
With respect to the text messages in the wiretap are as they were sent through the carrier. So,
okay, and which carrier? Have we already had all of the various carriers come in and
I think it's
certify?
It's Verizon, and no one has talked wiretap That has not been broached yet.
Well, I'm broaching it now
No,
because
I mean,
it's in
through a-
this, it's in this motion and limited.
Through a witness in front of the jury. That's what I meant.
Okay, so those records, then, we haven't had a business representative come in and
Correct.
say anything about those records. But are they going to ultimately?
We have a business record, I think.
Okay.
Just 1 second. What we have, I don't know. We have a witness, the team. And the way that the information is captured.
Just for clarification, Your Honor, when you say the wiretap custodian, who are you referring to?
Who?
Mr. Sherer, S-H-E-R. S-R.
Okay. And, okay, so he'll testify to how it gets captured, and is he going to be able to certify that it's accurate?
Yeah, I believe he will, just as much
Okay.
as yes, I believe that will be satisfied with that witness. Additionally, when we are, I believe that I understood the question last week to deal with not the text message box per se, but the one up under it, which was the notes, I think. And I don't recall if that was something that I misunderstood. That's not what we're trying to introduce. It's just the content of the actual text message box.
Okay. So is there anything else I need to entertain with regard to that?
I don't believe so, but I'll let counsel speak for themselves.
Defense counsel?
This message, I'll meet you tomorrow at the Braves game. It is not collected the way I sent it. So it's somebody, the sworn person who is on the team who's allowed to be a listener or a reader of the contents of the wiretap would then read that, and they put in the line sheet, Brian Steele's text was to Carlton Matthews, I'll meet you at the Brave game tomorrow. If that's the way it is, I'm objecting, because then it's not the original. And then I want to know what you just said. If they can lay a foundation that they have the original text message, or Verizon, it was over my objection last time, but they kept it accurately in the course of business, I'll waive this objection, but I do need unless he found it out now. He said that he would make sure which way it is. If it's an actual replica or if it's a human being.
Sure.
And that's my
that
issue.
would definitely be kind of a different circumstance.
And we verified, Your Honor. So with the message that came in through the phone, our understanding is while you're in the wire room, you can either accept or not accept it. So you can either accept it as it comes in or not accept it and it won't show up. But the person viewing the wiretap cannot manipulate the text message box. The other box is their own notes.
That's the notes
That's
box.
the notes. And we're going to try to show you an example. We were trying to find an example with both, but we can share the screen.
Well, y'all don't, do I understand you to be saying that the state does not intend to even try to introduce anything from the notes synopsis section boxes?
Correct.
But only from the text message boxes, which are supposed to be a verbatim capture of the text?
Yes, Your Honor.
Okay.
That foundation laid, yes.
Okay. All right. Thank you.